In a major blow to mass surveillance, the European Union's highest court issued a landmark ruling in a judgment that challenges key parts of the so-called Snoopers Charter. The UK's sweeping surveillance bill was set to become law by the end of the year. The Court of Justice of the European Union found that indiscriminately storing private citizens' communications is illegal under EU law. The court ruled that data storage is only allowed when government agencies are investigating a serious crime like terrorism. The judges arrived at their decision by raising concerns about the viability of storing all this data. Under the new act, communications data can be stored up to a year for reasons that go far beyond what is strictly necessary for fighting serious crime. The judgment also demands the government rethink the so-called internet connection records, which could include storing browsing histories for up to a year. Camilla Graham-Wood, the legal officer with the rights organization Privacy International, held the decision. She says, "It makes clear that blanket and indiscriminate retention of our digital histories can be very intrusive forms of surveillance that need strict safeguards against abuse and mission creep." She says, unfortunately, those safeguards are not present in the Investigatory Powers Act, which is why it's a Snoopers Charter. And as the director of human rights group Liberty points out, this ruling is the first serious post-referendum test for the government's commitment to protecting human rights. Martha Spurrier added, "The UK may have voted to leave the EU, but we didn't vote to abandon our rights and freedoms." The case now heads to the UK's Court of Appeal, where judges there will consider how to apply it nationally.